pleasure to introduce our guest speaker. As a matter of housekeeping, please make sure you're on mute, and if you have any questions, type them into the chat window and they'll be addressed at the end of the session. Before we get started, however, I'd like to acknowledge the original custodians of the land on which we meet. For me, that's the Wurundjeri people of the Kulin Nation, and I'd like to acknowledge their elders past, present and emerging. I'd also like to acknowledge the Melbourne City Council. Their support allows us to put on these webinars. Now, unfortunately, our listed guest speaker, Judy O'Connell, the Victorian Small Business Commissioner, is unwell and sends her apologies, but she also sends her 2IC, Mark Schramm, in her place. Mark is the Senior Manager of Dispute Resolution for the Victorian Small Business Commission, and he knows the topic inside out. The VSBC advocates on issues affecting people in small business and builds awareness of their rights and responsibilities. They also provide a quick, effective and low-cost dispute resolution service for small business owners. Mark brings a wealth of experience to his role, having worked for the VSBC for many years now. And apart from all of that, he's a great advocate for the small business sector. He's a personal friend of mine, and he's someone that simply gets it. So please welcome Mark Schramm, and I'll hand it over to you, Mark.
Thank you very much for that brilliant introduction, David. Thank you very much, and good to see you again. And here we have on the screen, and I should say, yes, I'm filling in for Judy, so who knows where this will go. I found out this morning, unfortunately, she's not well, so she sends her apologies, and well, this could go anywhere, but let's hope it stays roughly on centre to do with commercial tenancy relief and the tenancy relief scheme that the government implemented. We'll go through that in the main. On the screen here, we can see Kiomi, who's one of the tenants of the small businesses below the Small Business Commission's office on the corner of Burke Street, and which I haven't been there for a while. Burke and Exhibition, I haven't been there for ages, it seems, but hopefully we'll get back there before too long. So without further ado, let's talk about the commercial tenancy relief scheme, if this PowerPoint that I've crafted works. So look, just before I begin, of course, the Small Business Commission, as probably many of you know, has a general commercial dispute resolution function under the Small Business Commission Act 2017, which is only about so big. You can easily look at it on the Victorian legislation website, and it sets out the Commission's role and functions, the hallmark of which is to enable us to resolve any business to business, business to government dispute along the broad spectrum of commercial activity. And as you'd imagine, that spectrum is quite broad, so therefore so are the types of disputes that we can become involved in and mediate. And I'll talk a bit more about that process in a minute. So, and there's no definition of small business, so we always say if it looks and smells like a small business, then we're happy to assist and become involved. We've even mediated some disputes among partners, partnership disputes and shareholders even, because we take the broad view that it benefits the small business. And we've successfully mediated those types of disputes. So you can sort of see that we're prepared to sort of extend the jurisdiction, and we don't dwell on the jurisdictional point. And it's quite funny when sometimes law firms say, oh, you don't have jurisdiction. And we'll say, well, really, what the nub of this is, do you want to resolve the dispute or not? Oh, and I should, before I forget, I'll just mention too, we're always advocates of the small business mentoring service when we have disputes. We're always mentioning that the SBMS is another arrow to the quiver, and sometimes when we were dealing with some of the rail redevelopment disputes, some of the businesses hadn't really thought about that option of thinking laterally to get a mentor to have a talk to them about other things they might do outside of just trying to resolve a dispute. So I thought that was interesting. And the last thing I'll quickly mention here is that I understand that there is the Victorian Financial Counselling Service is being extended to provide free financial counselling to small businesses, and probably, David, you know more about that than I do probably, but I see that as an opportunity, as an adjunct to what the SBMS does, and maybe some of your, I don't know whether some of your mentors might be involved in it, but I just thought I'd just quickly mention that because it came up in the last week or two. So that's the part about the Small Business Commission Act. The Commercial Tenancy Relief Scheme. Okay, well, probably most of you know that the government in Victoria put in place the Commercial Tenancy Relief Scheme under the COVID Omnibus I like to say, hit by the omnibus. That's how it feels sometimes. But anyway, we've managed to get through it in implementing the omnibus regulations, which is what implemented the national code, the national tenancy code in Victoria, or sorry, the national principles for helping landlords and tenants. That's how it was enacted in Victoria in the COVID omnibus emergency measures, leases and licenses regulations. And the key parts of the CTRS, if I can put it that way, to use an acronym, the key parts were to establish or to put in place a moratorium on evictions where tenants have followed the process for rent relief and they can't pay their rent, but they have to have followed the process for rent relief in order to get a protection against being evicted during the period, which is from the 29th of March now to the 31st of December. And I'll explain why that was so, because originally it was to the 29th of October, and most of you probably know that. And the second key part was to put in place a procedure for tenants to obtain rent relief in the form of a rent waiver or rent deferral. And of course, the other key part of it was to put in place a mediation service through the Small Business Commission for tenants and landlords to help them negotiate these deals about rent relief. Now, I mentioned that the scheme was extended. So originally it was set to finish on the 29th of September. It was extended in late October for the end date to become the 31st of December with some changes. And the key changes were, and I'll explain how they work. First part of it is that the landlord is only required to offer rent relief to the tenant, and this is really critical, from the date the tenant makes a compliant written application to the landlord for rent relief during that period, and from that, and only from the date that the application complies, supplying all the information that the tenant has to provide, and I'm going to go through that. So have a look at the process on our website. There's a link there at the bottom, which is very helpful and which we wrote, and steps out the process. And before I move on from this slide, you'll notice there are a lovely photo of strawberries. You're thinking, why is there a photo of strawberries there? And there was a picture of a bloke, a tradie, with his arms crossed. And, you know, we always have these sort of ubiquitous photos of tradies supposed to represent a small business person. Well, this is a photo of strawberries I took in Japan from an actual small business. So I just thought I'd, it's a nice photo. I just thought I'd put it in there, and maybe you like that, maybe you don't. But there you are. It's a real photo from a real person. There we are. We'll move on. So now, other key changes. I promise there's no more random mentions of photos. The other key changes are, so under the extended regulations, sole traders can now be covered, because in the previous iteration they were not covered. But they have to participate in JobKeeper to be eligible. The big change also was that rent relief provided by a landlord, it has to be at a minimum in proportion to the tenant's turnover reduction associated with the premises, it says in the regulations, as I said in the previous slide, from the date of the tenant's application to the landlord. So for example, if the turnover is reduced, fallen by 40% compared to the corresponding period in 2019, then the rent relief that the landlord has to offer must be at least 40% of the rent. Now, what does that mean though? Rent relief is defined in the regulations. It doesn't mean that the landlord has to waive all of the rent. Whatever that rent relief figure is, at least 50% of it has to be in the form of a waiver, and the remainder is provided for in the regulations, and it's usually in the form of a deferral, but it can be another indirect form of rent relief, whatever that might be, such as, I suppose it could mean the landlord could come and do work at the tenant's premises and get paid for it, and that could be a credit. But generally speaking, the regulations provide for the remainder to be dealt with by way of a deferral of rent, and it's repaid from the 31st of December, as you'll see in a moment. Now, another key change in the regulations from the 29th of September was that the Commission was given the power to make a binding order for rent relief. And that can only occur where the landlord failed to respond or fails to respond to a dispute notice in the form that we require. And we put a form on our website, and I've got some more links for that, for various ways that tenants and landlords can must respond and to comply with the regulations. Or if the landlord doesn't mediate in good faith, then the Commissioner can issue a certificate stating that that a party hasn't mediated in good faith, and that's the Commissioner is reliant on the recommendation. If it's to do with a formal mediation, reliant on the recommendation of the mediator, or if it's before mediation, if one of our dispute resolution officers is, I guess, told to, well, for want of a better expression, to bugger off, and there's complete lack of good faith, then that certificate could be issued at that stage, which would then trigger the tenant being able to apply for a binding rent relief order. So that's the key, some of the key changes there. Now, it's quite prescriptive in terms of the extended rent relief scheme was quite prescriptive, or is quite prescriptive in terms of the information that's required to be provided by a tenant. So I'll step it out, and this is in the process on our, if you go to our website, on the big banner on our website, there's the COVID banner, and you click on that and you follow your nose and you'll find the commercial tenancy relief scheme information, and there's a process stepped out very clearly about what a landlord has to do and what a tenant has to do. So the tenant has to write, of course, to their landlord to tell them what it is they have suffered in terms of a decline in turnover. And to do that, the tenant can compare their GST turnover for the quarter ending 30 September with the corresponding period in 2019. So that's called the turnover test period. And the CPA Australia advice was that the tenants need to use the same method for those two periods to work out what that reduction is, like a cash or an accruals basis. Probably means a lot more. Well, I think I understand what it means, not being an accountant, but then it needs to be the same method. So that's the first part of it. Then we come to evidence of a decline in turnover as supported by documents, and the regulations provide that the evidence of a decline in turnover must be one of these things: an extract from the tenant's accounting records or the copy of the BAS, and we've got an example on our website linked to that information that I referred to a moment ago. And we have then the statement issued by an authorised deposit-taking institution, which is a long-winded way of saying bank, or a statement prepared by a practising accountant. So that's the documentary part of it. And then even further, as I say, very prescriptive, the tenant has to provide evidence that they're taking part in JobKeeper. And that can be done by providing a copy of the business registration for JobKeeper wage subsidy receipt number. There's an example there, which can be obtained by I guess I think it's a PDF version, or I think the advice was that tenants could contact the ATO's call centre and get a copy of the receipt number at least. And a copy of the most recent notice to the ATO under the JobKeeper rules, which is here as an example. And again, these are linked to our website. That's an example for an entity with less than 240 employees. It's very important for tenants to redact the confidential information that these statements contain, because these are screenshots of what a tenant can download as a PDF. So they'd have to redact the TFN and the names of people, I guess, if they were going to provide it. That's the one for above 240 employees. Yeah, so that's the types of information that the tenant has to provide to be absolutely compliant. Having said that, what we're hearing is that a lot of landlords aren't really, surprisingly perhaps, relying on the letter, the absolute black letter, and requiring all these hoops to be jumped through, provided there's a sufficient sort of range of information given about the loss in turnover. So perhaps going back to those other documents that I mentioned, that's what we're hearing anyway. And then the tenant also has to sort of include in their statement that their lease is eligible under the Commercial Tenancy Relief Scheme, and that they are an SME. That's purely just a statement that they're an SME, as far as I can work out from regulations. So I mentioned before we had some templates and forms and things on our website. So here's a template that we wrote to assist the tenant to seek rent relief. Quite a lot of information there, and I won't read it all out, of course, but it really encapsulates that information that I just went through, the various categories of documents, which is a good aid memoir for tenants to be able to tick off as they go through, and explains the regulations as well. So the landlord has to respond within 14 days once they get the compliant rent relief request from the tenant. The landlord has to respond, and then the regulations provide that there has to be negotiation in good faith, but the landlord has to provide an offer within 14 days. I put, for those of you who seem to want to know about regulations and where specific things come from in the regulations, there's a few other requirements here where I'll just whiz through them. So Regulation 5, there was a question under the previous regs about whether the regulations allowed for, or whether JobKeeper payments were part of turnover, and that was clarified in the extended part. The next one was Reg 10. The key change here is that the rent relief application, it must be associated with the premises and no other premises, I think it says. Now, did I get that right? I just better check that, because I just better make sure that I've got that exactly right, that Regulation 10. Associated with the premises, I don't think it says and no other premises. Oh, no, it does, and no other premises, yes, and that was changed. So what does that mean? I suppose the question there is, well, what if the tenant has other premises, such as, for example, what if they had a warehouse that they're leasing and a shop that is supplied by the warehouse, which is also leased? What if both of them are the subject of a rent relief application? Well, it's not settled. There's no case law on this yet. There's no sort of definitive ruling on what is associated with what does it mean? But I highlighted as an area that needs to be potentially clarified, I suppose. I don't have all the answers to this, but I can tell you what the requirements are, and that's one of the requirements. Regulation 10 says that the landlords, well, that was redacted. Under the previous iteration of the regulations, the landlord could consider their own financial capacity, but no longer. That was actually taken out of the extended regs. So it really seems that with these extended regulations that it's purely about proportional reduction in turnover equals the landlord must offer rent relief. And a lot of landlords are, I think, are not potentially not happy about that. That is the situation. And the repayment date, previously it provided that repayment where rent has been deferred could not, the landlord could not ask for that rent until the earlier of the end of the lease, or the 29th of September. That's just now the 31st of December. Another change was that there's no rent increases allowed during this period from the 29th of March to the 31st of December. And probably the last one I'll mention is that rent relief applies to, if there's a tenant paying gross rent, then the rent relief must apply to the gross rent figure. There's no carving out of the outgoings. It's provided for specifically in Regulation 10.4a, so that's that. Now, a tenant can make a subsequent request for rent relief under Reg 11. So if their circumstances have changed, or if the agreement wasn't proportionate to their decline in turnover, and if the agreement didn't cover the whole period, the previous agreement, the tenant can apply for further rent relief, but they have to follow the process which is laid out in the regulations in terms of the prescriptive requirements that I've gone through. And previously, that subsequent rent relief, if the landlord was to grant it, could do it purely by way of deferral, but that's been changed now, so that there's no requirement to just confine it to deferral. It has to be like the first part, at least half of it has to be in the form of a waiver. So what happens if agreement can't be reached? Well, then that's where we come in. So just like the commercial dispute resolution scheme that I explained at the start, either party can make an application for mediation under the commercial tenancy relief scheme, and that applies whether the tenant is eligible or not. So even where a landlord and tenant or where a tenant's not eligible under the scheme. For example, let's say they have too much, the turnover's too hot, or hasn't fallen enough, or they don't qualify for JobKeeper because their turnover is in excess of 50 million, or they're part of connected to a group, therefore excluded from the regulations. When I say connected to a group, if they're part of a corporate structure which causes an exclusion, then if a tenant's ineligible, we'll still allow the either party to apply for mediation under our normal pieces of legislation, the Retail Leases Act or the Small Business Commission Act, but we'll encourage the parties to make every attempt to resolve the dispute based on applying the principles of the National Code, which set out the same sorts of principles. In fact, we'll encourage them to apply the same principles under the regulations. It's just they're not obliged to, the landlord's not obliged to make that offer of rent relief if the tenant's ineligible. But if mediation can't solve the dispute, and that's defined as including at the preliminary stage by one of our dispute resolution officers, or if one of our dispute resolution officers can't resolve the dispute, it then goes on to a formal mediation with one of our independent mediators. If the dispute can't be settled, then it can go on to VCAT presumably for a determination about what the rent is to be. But as far as I know, there's only about 2 or 3 in the pipeline so far at VCAT. But that's because we've been able to solve many of these disputes, and I'll tell you a bit about that. So we've had, since the 29th of March up until 28th of November, we've had 13,152 inquiries about this. We've received 3,168 rent-related dispute applications, and you can see there on the screen the breakup between commercial tenancy relief scheme matters and the ones that are not eligible. And we've been able to finalise a lot of them, 1,686. And again, there's a double breakdown there of the ones resolved by our DROs, we call them, dispute resolution officers, before mediation, and the ones 903 at mediation, which gives us a success rate of 86.7%. So that's why not many have gone through to VCAT, which is VCAT are quite happy about that. So it's taken us a while though. So you can see that the time taken to finalise somewhere between 7 to 9 weeks thereabouts. So it doesn't happen overnight, but we do get there. And overall, just for those who are interested, for the last financial year, just in terms of all our disputes, there's the sort of the stats for the normal, if I say normal, the overall dispute resolution picture. So we've had when I say record, another year where the dispute application numbers were more than the previous year, and that's sort of pretty much been year on year since we commenced. So overall, 81% were successfully mediated. So 38%, I should say the CTRS ones, we're resolving about 43% of those before mediation, which is pretty good. And you can see there 38% of other types of disputes, such as retail leasing, owner-driver disputes, farm debt disputes, small business commission disputes, the general commercial disputes, 38% being resolved prior to mediation, which is pretty good. Now, a few questions. What if you're a landlord and the tenant stopped paying rent? Well, I've sort of answered that. We have a free and these mediations are free, these COVID mediations. Normally we charge $195 per party, but which is heavily subsidised, but these are free. The tenant has to follow the process for requesting rent relief in order to be protected, as I've said. But we can, basically, we can mediate the dispute if the landlord and tenant can't come to an agreement, which is, I guess, what I've already said. Plenty of advice on the website too in that last link. Oops, where are we? Going too fast. Can the rent be increased? No, it can't be, and I mentioned that, didn't I? So I don't really need to dwell on that. The rent can't be increased during the relevant period from 29 September to the 31st of December, unless the parties agree otherwise, of course. A couple of other things worth mentioning, that landlord supports. So we have some land tax supports, which most people, or many people, may know about, involving a 25% reduction on the 2020 land tax liability and a deferral of the remaining land tax. So This is where landlords who provide eligible tenants with a rent waiver of 50% over 3 months can receive land tax help, and they can receive an additional 25% reduction up to 50%. I see here, I'm blocking my screen's kind of blocked out, but and there's also land tax benefit for owners of commercial properties who run businesses from the property and they've been impacted by COVID. So a lot more of that information is on the SRO website. We do get a few questions about people wanting to end the lease, and these range from if a tenant's on a periodic tenancy, a month-to-month tenancy, does it constitute eviction, for example, if the landlord doesn't allow the tenant to stay on? And the answer to that is no, because if a tenant's on a month-to-month tenancy, then at the end of each month, of course, unless both parties renew the lease, then the lease comes to an end. That's the nature of a periodic tenancy. So the landlord doesn't need to renew the lease. It's just that the landlord can't evict a tenant where there is a lease in place, if that makes sense. Of course, there's other requirements that people have to watch out for, like under the Retail Leases Act, Section 64 requires the landlord to have given the tenant a notice no later than 6 months before the end of the lease as to whether they're going to renew the lease or not. And if the landlord doesn't do that, the Retail Leases Act says that the lease continues on forever until the landlord gives that notice, and then the tenant gets 6 months. The end date becomes 6 months from when that notice is given. That's a very much something that probably a lot of landlords don't do and don't know about. But generally, if a tenant, and then we get questions about what if the tenant wants to end the lease, and so the advice here is that a tenant, of course, if there's a deal in place, they're obliged to pay rent to the end of the lease. But there are circumstances where, and we've had them, where landlords have wanted to get the premises back. There's other circumstances where, well, look, they're happy to relet it to someone else. So the general principle is that if the tenant does break the lease, of course, the landlord can't sit back and do nothing. The landlord has to try and lease it out to someone else to mitigate their loss, but the tenant can be required to pay effectively damages if they do break the lease early. So, and that can be in the form of a surrender amount in lieu of lost rent sometimes. But generally speaking, we encourage parties to negotiate and to try and get a deal done through our process if necessary. Oh, heck, we come to the end already. So I'm sort of horrified that I might have gone a bit too quick, but perhaps there'll be some questions, and well, we might end up sort of somewhere halfway decent towards the full hour that I was supposed to speak for. So I hope that wasn't too quick, but yes, I hope that was at least half edifying, and we'll deal with some questions if we have any.
Thanks, Mark. That's very informative. There's a number of things that I'd like for you to clarify for us, independent of the issues of landlord tenancies at the moment under the coronavirus challenges. What are the other sorts of mediations that the BSBC might entertain, might be involved in mediations over?
Well, we're still getting, funnily enough, we're still getting a lot of, and just recently, a lot of non-COVID applications for mediation. And so the other pieces of legislation I mentioned were the Retail Leases Act. So we have a lot of information, advice and guidance on our website about the rights and obligations of landlords and tenants in relation to retail leases. And so under the Retail Leases Act, for example, the landlord has to repair and maintain the premises. The landlord has to compensate the tenant if the premises are damaged. I know I'm focusing on landlords here, but this is, as one of the court cases mentioned, is ameliorative legislation. So it's legislation designed to, in the main, to put in place protections for tenants, and there's no apology for that. That's what it is. If you read the second reading speech, but so so under the Retail Leases Act, things like disclosure statements. The tenant has to be given a disclosure statement and a copy of the lease at the commencement of negotiations. the landlord has to give the tenant an annual estimate of outgoings, which tells the tenant what they've got to pay. The landlord has to give the tenant a reconciliation statement at the end of each financial period. So we get disputes along the lines of those things, and so that's continuing, that dispute resolution work. And then I mentioned also a few times the Small Business Commission Act. So we're getting still disputes, general contractual dispute resolution matters where maybe there's a failure on one party to supply what they promised they'd supply, or a failure by one party to pay for something, or a dispute about delays in services being provided. We're doing those sorts of disputes with, and very briefly, we have a smaller dispute. When I say smaller, because we don't get as many applications for mediation, but we have a dispute resolution role in relation to owner drivers, so disputes between hirers and hirers of drivers and contractors who provide driving services, like your Uber Eats and your trucking companies, small individuals that provide trucking services, and also farm debt mediation disputes between creditors and farmers. So that's sort of where we're at with the other types of disputes and the other bits of legislation that we administer.
Yeah. And I noted that you commented that you don't have to qualify for the rent reductions in order to be able to seek mediations with your lease negotiations at this current time.
Yeah, well, it's interesting. The National Code, I imagine most people would be aware right back at the start when all this happened. There's the big announcement by the federal government about this National Code for lease. I keep forgetting the exact title of it. The National Code for Leasing Principles, I think it was actually titled. And a lot of people thought, well, that's law. But of course, it wasn't law. It's only law because each state enacted legislation in the form of regulations under the, once each state had enacted or at least in Victoria, a COVID Omnibus Act under which regulations could be made. That's how it became law. But of course, those regulations, as I mentioned, only apply to eligible tenants under eligible leases, and there's a number of carve-outs where tenants are not eligible, where they earn too much in the way where they don't qualify for JobKeeper because they earn too much in the way of turnover, or where the tenant is part of a corporate structure where they're related to another company, and that's defined as those are defined in the regulations and the Act as not being covered. Where a tenant, sometimes you've got situations where you've got a small, and this can affect very small tenants, where you've got, for whatever reason, they set up one company to do the trading and another little company maybe to set up to hold the lease. But the problem is the company that does the trading and might employ people might not be the tenant. You've got two different entities doing two different jobs, but they're really, practically speaking though, everyone knows what's going on. That maybe it was done for, I don't know, to enable a family trust disbursement of monies, or maybe it was done for asset protection or whatever. But the fact of the matter is that the tenant in that scenario is not receiving JobKeeper because it doesn't employ anybody. It's the other company that's doing the trading that employs everybody. So that in that situation, the tenant wouldn't be eligible. But we've encouraged, to get to the answer, we've encouraged landlords and tenants to come to mediation even where the tenant's not eligible for those technical reasons, and to apply the same principles about proportional reduction in turnover and rent relief and deferral, the same principles that were put in place in Victoria, which were drawn down from the National Code. So we've been reasonably successful in being able to get mediations resolved on that basis.
Okay. Mark, I've got a couple of questions in the chat area. First one is, may I confirm that the landlord is entitled to give notice to vacate the premises to a commercial tenant who is on a periodic lease?
Was the question, can I confirm that?
Yes, that the landlord is entitled to give notice to vacate the premises to a commercial tenant who is on a periodic lease.
Well, I'd probably put it more on the basis that the landlord's entitled to, subject to what I said about Section 64 and the 6-month notice requirement, I'd probably put it more on the basis that the landlord is entitled to confirm that the lease is ending on the date that it is supposed to end on, as it would do under a periodic tenancy. So it's probably a slightly long-winded way of saying yes, but you might want to just rather than use the language of saying, you know, I'm recovering the premises or I'm terminating the tenancy. It's probably more realistic to reflect what's actually going on, which is that the landlord's not renewing the lease, which is a different thing, I think. Perhaps semantics, but I think it's important.
I also understand that the deferral of rent or rent relief by deferral, the landlord has to continue your lease in order for you to be able to repay that deferred rent. So if, for example, you only had a lease that concluded mid-year next year, but you have had a 40% reduction in your rent, of which 20% is deferred and 20% waived. That 20% deferred can be negotiated to be over an extended period of time. And so therefore the landlord would have to give you the time, a reasonable period of time to make that repayment. Is that correct?
Not really, no. The deferral, if rent is deferred, Regulation 16 says that the landlord and tenant must vary the eligible lease so that the tenant must pay the deferred rent amortised over the balance of the term of the eligible lease, including any extension to that term. And now that extension comes about because if rent is deferred, it says the landlord must offer the tenant an extension to their lease equivalent to the period of deferral. But that deferral period only arises between 29 March to 31 December. So give you an example, if the deferral is for 2 months, say for example for November and December, the tenant can defer those 2 months of rent, because now we're in December actually. But let's say rent's been deferred for those 2 months. That means the landlord can offer the tenant, or must offer the tenant, which the tenant doesn't have to accept, by the way, but the landlord has to offer the tenant a 2-month extension to their lease. But then it says, so the landlord and tenant must vary the eligible lease or otherwise agree, so the tenant must pay the deferred rent over the greater of the balance of the lease, including any extension that we've just talked about, or a period of no less than 24 months. So you can have a situation where even with an extension, the lease ends, let's say the lease ends on 30 June next year. But we know here that it says the landlord has to allow the tenant to pay the deferred rent over the greater of the balance of the term of the lease, which could be 30 June, or a period of no less than 24 months. So you could have a situation where the tenant's paying back rent over a 24-month period where the lease has ended.
Right, so 18 months beyond the term of the lease.
Correct.
Yeah. Okay. I've got a question here. Is there any discussion about any incentives post 31st of December? We still have limitations to trade, limited office workers in the city, density limits, etc. Or will it be business as usual post 31st of December?
Look, I think we'll find out more about that. I suspect we will find out more about that this or next week.
Yeah.
I don't know of anything yet.
Okay. I've also got a question. I need to get advice about how to liquidate my small business, bearing in mind the new SME liquidation regulations that will come into effect at the end of December. Is there a government agency that can assist with that? Are you aware of an agency that can help on that?
Well, I know for personal insolvency, there's the used to be called the Insolvency and Trustee Service. The Commonwealth Government's insolvency body. I suspect ASIC has advice about corporate insolvency matters. So I'd probably, in the first instance, have a look at ASIC's website and see what information and advice and referral guidance it has about insolvency procedures. And I'm sure from there you'll find where you need to go. Probably that's all I can say about that.
Yeah. I also had a question about the landlord who believes they just ran out 4 walls to the person in the room. They expect me to pay all of the outgoings and all of the repairs and maintenance, even though they have installed the grease trap and kitchen exhaust. Am I able to claim back past repairs over and maintenance expenses from the siting from 2014 to the present? So can they claim back past repairs that the tenant has done?
Yes.
Yes?
I suspect the answer is yes. The Retail Leases Act can't be excluded because there's a section in it that says, section 94 actually, it says you can't exclude the operation of the Retail Leases Act with an agreement to the contrary. In other words, you can't contract out of it, you can't avoid it. It's an anti-avoidance provision, section 94. So if that money's been paid by way of mistake, and the landlord should have paid it, then it's quite, I mean, look, I should say with all of these things I'm saying, by the way, the Commission's role here, and I better spell this out, the Commission's role here is to tell part of the story, which is to give guidance about the application, to give guidance to people about what these regulations state. But of course, the law about retail leases and the law about tenants and landlords is governed by 3 things. It's governed by what's in the lease, it's governed by the Retail Leases Act, the regulations, and it's governed by the common law, which is the law, and to a lesser extent, the rulings of the tribunal, the Victorian Civil and Administrative Tribunal. So the Commission's role, and that's my role, part of my role is really confined to the one part of those 3 things, which is to give people guidance about what the Retail Leases Act states. So I'm probably going beyond my responsibility, I guess, or even what I'm allowed to say about how these things, those other 2 things, how the lease is to be interpreted, or how the common law interprets the legislation and interprets previous decisions. But having said that, I know enough to be dangerous, and I think pretty much in that situation, the tenant would have quite possibly a claim to be able to recover monies paid by mistake, or where the landlord and the tenant have operated under the misconception that somehow their agreement excluded the operation of the Act. So, but of course, you have to check that with your own legal advice.
Yeah. So the other way would also be to possibly contact the VSBC and potentially have a discussion with somebody in your office and explore mediation opportunities.
That's right. Practically, if a deal can't be done, you can try and do it through mediation, and who knows what outcome. And also, the Law Institute of Victoria has a half an hour's free legal referral service.
Yeah. There's a question from Minnie. For the negotiation process, it needs to be finished, finalised within the 31st of December 2020 for the tenant protection on receiving rent relief. So is that the case? Is the mediation or the negotiation process, does that have to be concluded by the 31st of December?
That's a good question. I think not. I think that provided that the tenant has made a compliant rent relief application to the landlord within that period, that is at the heart of it. That is the main requirement, because in Victoria we have the Interpretation of Legislation Act, and it says, I think it's around about section 58 from memory, buried deep in the Interpretation of Legislation Act. There's a very interesting section, and it says just because legislation expires doesn't mean automatically everything just sort of poof goes off into the ether. What it says in that section is that previous rights and obligations that are created by a statute don't expire on that legislation expiring. They continue on. So the main thing here, I think, is that the tenant has put in their application.
Excellent. I think that's a really valuable answer for you there, Minnie. There are no further questions in the chat room. I wanted to just cover off on a couple of things. First of all, my experience with the Victorian Small Business Commission has been a phenomenal experience. The VSBC does some extraordinary work, and as Mark mentioned earlier, for $195 for mediations for both parties, it's a phenomenally cheap service, hugely subsidised by the state, and their success rate, well, no one can argue with 86, 87% success rate. So that's extraordinary in the first instance. Second, very easy to get support from the VSBC, and many cases disputes are resolved well before it ever gets to mediation. Just the very fact that the VSBC has been in contact is often enough, isn't it, Mark, to make the parties come to a reasonable conclusion. So contacting the VSBC is a really valuable thing to do. That can be done either through the 138722 number or through inquiries@vsbc.vic.gov.au. Lastly, I would just like to thank Mark for coming in today, and particularly on such short notice, and please pass on to Judy our very best wishes for you to get better soon. And again, thank you for your advice today. I would ask also, would it be possible for us to have a copy of the PowerPoint presentation so we can refer any information on to anybody?
Sure, no problem.
All right, thanks everybody for attending the session today. I'll conclude the session at this point. Again, thanks to Melbourne City Council